Hi guys, welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Fruit Loop, what you know?
Oh my goodness, I know you done fell asleep.
Oh
Y
man, I fell asleep on the couch and I wasn't planning to fall asleep. And thank God I almost fell off the couch and woke up because I would have not been able to pick my daughter up from school.
Yeah.
And then I see you blew my phone up. Can we?
Yeah, I called you. I'm like, "Let's get this done," and I'm like, "She's asleep."
Oh, dead to the world. Just, yeah, guys, sorry. Like my face is
So,
puffy and
what I do know is, did you know that chewing gum boosts your concentration?
Lord, some people must have some real good concentration.
Yeah, it was a British Journal of Psychology found that subjects who chewed gum while taking part in a memory challenge were able to stay focused for longer periods of time than those who did not chew gum.
That's interesting.
What?
People that chew like cows must be, super focused.
Super focused. That's why I didn't do good on SAT. I wasn't chewing gum.
Yeah, yeah, yeah. I don't wanna hear that. I think we stayed out till, 3 AM the night of the SAT.
Yeah. Yeah, it was not good.
Alright, so we wanna give a quick shout out to our sponsor, Too Cool T-Shirt Quilts. If you would like to have a super cool t-shirt quilt or pillow like you see behind me, you can go to twocooltshirtquilts.com/prettyliesandalibis and make use of those old t-shirts you just got laying around, but you can't part with. My mom, in honor of our millionth download, got me the Pink Floyd shirt from last night and the super cool Journey shirt. So thanks, Mom. She's leaving tomorrow to go on her cruise. She gets to go. All right. So we're going to jump into this. There's been some filings that we are just a little behind on. And what we're going to do too is either today or tomorrow, we are going to summarize the Curtis Reeves trial. It'll be a little bit different if you followed us during Halderson. We're not going to get as involved in all that testimony, but we are going to start summarizing a couple of days at a time to stay on top of it. I'm really super curious about this verdict. I think it could go either way, even though kind of seems obvious what happened, but I think his age could be a factor, and I think a lot of it really depends on the age of the jury. All right, so we're gonna jump into Josh Duggar right now. His sentencing has been set for April 5th, and the prosecution responded to his attorney's request for a new trial. And it says the defendant now asks the court to overturn the jury's verdict, claiming there is no evidence he personally viewed the child abuse material.
Um, didn't they prove all that?
We just had a whole trial about this. They proved it, and a jury of his peers said, "Yep, they proved it." But here we go.
Yeah.
The defendant now asked the court to overturn the jury's verdict, claiming there's no evidence. I think I just read that. Sorry, y'all. I'm still half asleep. I got my coffee though, and I got another one sitting under the Keurig. So the defendant also asked the court to grant the extraordinary remedy of ordering a new trial for a variety of reasons, but these arguments fail too. He claims that the court prevented him from calling as a witness Caleb Williams, a man who could not have committed these crimes based on the defendant's own evidence, but who he nevertheless sought to implicate, and criticizes the timing of the disclosure of emails from Mr. Williams. But contrary to his misleading framing, he was not prevented from calling Mr. Williams. He simply opted not to when told he would need to satisfy the federal rules of evidence before improperly injecting Mr. Williams' prior sex offenses into the trial. Those are fighting words.
It's on. It's
It's all
on.
like Donkey Kong. So further, the emails at issue are wholly immaterial, but they were still disclosed promptly after they were reviewed and in time for the defendant to attempt to utilize them at trial. He also argues that a new trial is warranted because of the timing of the disclosure of the government's demonstrative rebuttal exhibits allegedly violated Rule 16 and the Jinx Act, because the testimony about iPhone metadata from James Fertrell, director of the Department of Justice's High Technology Investigative Unit, was improper expert testimony. Can we just talk about the fact that his expert witness was not an expert? Typically, seems to me like watch some YouTube videos and said, "I'm an expert."
Yeah. We
Uh,
could have done that.
we could have
We
been
could
all
have
up
been
on
on
that
there.
stand. Can you
Yeah.
imagine us at a trial? I could
Oh,
not
no.
testify if you were sitting in that courtroom.
Yeah.
Let's just say that. I get held in contempt.
Yeah.
So The defendant last tells this court it must dismiss count 2 of the indictment with prejudice. While undeveloped, his argument appears to misapprehend the court's prior guidance and controlling precedent. The defendant's motion should be therefore be denied in its entirety. The notion that Caleb Williams committed these offenses is pure fiction, a story advanced by the defense for the sole purpose of casting blame, regardless of evidence to the contrary, on a sex offender. Yet the defendant now claims he's entitled to a new trial because the court precluded him from calling Mr. Williams as an alternative perpetrator witness.
Here's my question. I mean, they respond with saying you had every opportunity to call him as a witness, but you
Yeah.
chose not to do what you needed to do to call him. So did they keep that in their back pocket so they can throw this out?
Well, here's the thing. The deadline was quickly approaching for when they could file post-trial motions, and then we get this at the very last minute. I think it's a Hail Mary attempt to try to do something, but I don't think it's gonna go anywhere. We just had a whole federal trial about everything they're saying.
Yeah.
So
Yeah.
faced with the certainty that he could not establish the nexus needed to trot out the witness's sex offender status, the defendant elected not to call him. His failure to call Mr. Williams was therefore a strategic decision made with counsel, not a limitation imposed by this court, and his motion should be denied.
Dun dun dun.
Ooh.
Yeah. So the defendant could not and still cannot establish a non speculative nexus between Mr. Williams and the offenses, or even a nexus between him and the state of Arkansas during the charged time frame. He says, the defendant's theory that Mr. Williams remotely accessed Duggar's computer to set up this partition and download child pornography was disproven by his own expert, who conceded that someone had to be physically present at the computer on May 13, 2019. And we talked about it, Mr. Williams was not in Arkansas at that time.
Right. And not only that, but his witness said you have to be sitting there. Can I just apologize for slurping in the microphone? Because I'm trying to get this coffee in my body quickly because I'm just not there, guys. But I just realized I'm in the microphone going, my
You
bad.
didn't
Sorry.
mute. See, when I
Sorry for a
slurp, I
loop.
mute. Yeah.
Takes me like 45 minutes to wake up.
Yeah. So the only conceivable purpose in calling him was to confuse the jury. This is a great point, with evidence that a sex offender had peripheral contact with the defendant's car lot outside of the charged time frame. Regardless, it was not the court that prevented the defendant from calling Mr. Williams as an alternative perpetrator. It was his own assessment of the facts. While he might have hoped or even represented otherwise, there was no evidence to suggest that. Here's the deal. This is solely my opinion. If Mr. Williams was guilty, they would have went after Mr. Williams, I feel.
Yeah, I mean, he wasn't even there. It's not like, I mean, the average person cannot just access your computer from here, download a whole operating system. You have to be there to do that.
Yeah.
Makes no sense. But I mean, look, the dude's facing, and it's still up in the air. I've heard 20 years, I've heard 40 years. I still don't have a clear answer. At the end of the day, he's facing a ton of time, and this is all they've got at this point.
Yeah.
So this is just a shot in the dark, but he going to the pokey.
Yeah. So Mr. Williams was in Arkansas. We know this, between May 13th and May 16th, 2019, to commit the offenses. The most generous reading of the defendant's opening statement and his counsel's proffer to the court is that the defense may have been able to show Mr. Williams worked on the car lot in March of 2019, and that he operated an online business, both of which are irrelevant and in no way lend themselves to support a credible alternative perpetrator theory.
And that's the word. Yeah, I don't think this will go anywhere at all. He just knows that finally, for the first time in his life, kind of like other defendants we know, Lori Vallow, they're having to face up to what they've done, and they don't like it. So sorry, bye. Hope I don't hear nothing about that guy for at least 20 years.
For real.
Although the federal sentencing, it's questionable. I mean, he's a first-time offender. I think I've heard the average he should get is 5 to 7 years, which is scary, but that's for another episode. Let's move on to Leticia Stock. She had a court appearance last Friday, and the judge has decided that he will allow her to plead insanity, even though we've had 2, evaluations comes back that she's competent for trial. She'll be evaluated at the Colorado Mental Health Institute, and professionals have said they would not be able to have that report ready until April, which could throw a curveball because this trial is due to start at the end of March. So
Yeah.
we will see. This thing needs to get rolling. There's another hearing scheduled for this Thursday. Not sure what's going on with that. So, one thing we really haven't talked about is Lori had her status conference last week. It was closed to the public and sealed, obviously, because it deals with her mental health. Her 190-day extension is up on March 21st, so that's a little over a month.
It's 180, right?
Yeah. What did I say? 100. I think it's 190.
Is it 190? I thought it was 180.
Maybe. I think. Yeah, it's 190. I think.
Wow.
I mean, my
Look,
mental state is questionable at
y'all,
this point, but
it's either 180 or 190.
it's one of those.
One of those.
It's real. We've had a lot of people inbox and ask us what we think about
Mhm.
Lori. Sorry, it's 180 days. You're right, Fruit Loop. Sorry.
That's all right.
I,
10 days. That's all it
at
is.
this point, right? At this point, it would literally be a guess. I mean,
Yeah.
nothing indicates to us that they went either way. It seems like maybe they didn't have the doctor's reports again,
Yeah.
because that was listed that they needed those reports, and we have this other hearing on Thursday. So I don't know what's up. Couldn't tell you either way what they have decided. We know what we think.
I just
So
can't. I don't understand why you can't have all the paperwork there.
yeah, I don't know. I mean, this has happened twice if that's
Yeah.
what's going on, and it's holding the
Yeah.
court up. I
Yeah.
mean,
Like, we know she's competent. Let's go.
let's do it.
Yeah.
Let us be in charge of evaluating her.
I
Come
know.
on.
Get your booty off the couch. Let's go.
You cannot watch the Zoom hearing.
Yeah.
All
Come
right,
on.
so upcoming court dates for Chad, March 18th, 9:30 in the morning is the motion to sever. I'm interested to watch that.
It's a day before my birthday.
I know, I saw that.
What?
It's like a
Yeah.
pre-birthday present. You get to look
That's
at Chad
right.
doing this for hours.
Yeah. Birthday Eve.
March 18th, the same day at 11, the motion to allow additional evidence regarding the jury. That's where, the prosecution wants to have that jury brought into Fremont County so they don't have to move the whole trial. But I just don't think the judge is going to do that. But we shall
Yeah.
see. March 23rd at 9:30, there is a motion to dismiss, and I'm interested to watch that one as well.
So Pryor files a memorandum in support of the motion to sever. And we discussed this. He's got some, and we know we don't agree with Pryor. He gets on my nerves. But he does have some valid points here. He cites state versus, here we go, guys, Nava. The jury may confuse and accumulate the evidence and convict the defendant of one or both crimes when it would not convict him of either if it could keep the evidence properly segregated. Okay, then don't murder people with somebody else.
Exactly. Boom, ding, ding, ding.
That's what I want to say. So the defendant may be confounded in presenting defenses as where he desires to assert his privilege against self-incrimination with respect to one crime but not the other. The jury may conclude that the defendant is guilty of one crime, then find him guilty of the other because of his criminal disposition. And he also cites other case law which states a joinder may be prejudicial.
Yeah. Well, here's the thing. They're both charged with the same thing for the most part. There's a couple of charges that are slightly different, but I mean, look, we saw the amount of evidence that was in text for Charles and Brandon. For Charles's murder and the attempt on Brandon, I don't think it's going to be much different with the kids or with Tammy.
Yeah.
So they don't throw these charges out for fun. They already have evidence that they think they can prove to a jury that this happened. Not only that, a
Right.
grand jury indicted them. So, you
Yeah.
know.
So the argument is Chad is scheduled for trial in early January of 2023. And we know at the present time, Lori Vallow Daybell, which what did he say?
Daybell. He's using
Yeah.
Daybell now.
Yep. And Chad have not been provided medical information or updates as they relate to Lori. But here's the deal. I mean, right now you're not entitled to that.
Yeah, and as a husband, you would think if she signed a waiver, he would be able to get information, but I guess the fact that they're co-defendants in a multiple murder case might throw a wrench in that, and then he's not entitled to anything because you really can't have any contact with your co-defendant. So I wonder exactly why Chad couldn't get updates about her condition.
I mean, you would think that somebody that's talking to her would talk to him.
Yeah, like maybe even her family or something. I don't
Summer,
know. But
somebody. Yeah. But so Pryor assumes at the time of this filing her status is unchanged because he doesn't know.
all right.
Pryor just wants to know.
Well, we want to know too, so
Yeah, we
we
do.
feel you on that, Prior.
Yep. So Pryor says preparing the defense with uncertainty as to whether one of the co-defendants will be present for trial creates evidentiary challenges given the severity of the charges. In the event she is deemed unavailable due to her status, like I would think, right? Like that's part of it. Like you make a motion to exclude something. It's
Yeah, I mean, I really don't know what there is to exclude with the charges in Fremont County
yeah,
because she has conspiracy to commit murder charges for Tammy. Chad has murder charges. If I recall correctly, that might be the only difference in Fremont for them, where he didn't get charges for Charles's murder, but she did. So
yeah,
I don't know.
yeah. So the prejudice of these other wrongs or acts by Lori Vallow Daybell would certainly have an impact on jurors should these cases remain joined. Defendant Chad Guy Daybell would request that the state be ordered to present to this court in camera statements and other evidence it intends to offer from either defendant for the court to conduct the necessary analysis. However, the fact that defendant Vallow Daybell's status is uncertain, at least one other instance she is facing serious charges out of Arizona, and that her other behavior would have significant impact and prejudice to defendant Chad Daybell. Look, he's just trying to separate himself because he knows they both guilty as ever.
Oh yeah, and I think another thing too, not only is Pryor doing this to try to get a leg up to defend Chad, you almost wonder. I mean, I think that they've probably split as far as their allegiance to each other. But if they have not, maybe Chad doesn't want to go up against her at trial because it seems like they're going to have to point the finger. She made me do it, or she led me to think this, or I don't know. Oh, I do think it'll get severed though. Um, where did you leave off, Fruit Loop? I'm very sorry.
No, you're fine. Sorry, I had to go.
Yeah.
Okay, so the defendant Chad Daybell would be prejudiced by the other wrongs or acts attributed to defendant Lori Vallow Daybell, in her individual capacity. You like I said, individual capacity, despite the fact Chad is not facing the same scrutiny. The level of discovery in this case is beyond significant. It is important the court err.
Yeah, good job.
On caution and sever these two cases. So,
Yeah, so I agree with Pryor. I think they need to be severed. She has been incompetent for a while now, and I mean, at the end of the day, Pryor has been preparing this defense the whole time. She's been incompetent, and I hate it for the families if it's severed because they're going to have to sit through 2 of these trials. But not only that, witnesses will have to testify twice.
yeah, and I know
This
that's grueling.
trial is going to be moved twice. If this goes, I see a lot of downsides, but at the same time, maybe I'm curious to see what happens. I don't know. If she's competent now, if she's competent right now, I think that might be the only way that he doesn't grant it because we're not so close to the trial right now that it's an emergency. We've still got almost a year. We got 11 months.
Yeah, and they know what has been recommended. They just
Right.
need the documents to back it up.
Yeah, I think so. So we will see. We'll know, so her the motion to sever is March 18th. Her 180-day extension is up on March 21st. That's just a couple of days. We may find out on the 18th or get a clue if she's competent, maybe if
Yeah,
he doesn't sever. That's
yeah,
I'm not a lawyer, but that's kind of my way of thinking.
yeah. And I
If we
think
don't know before.
with everything right now, she's still listed as being there. So I
Right.
think that's thrown some question in. But if the documents and the everything wasn't right, they may be waiting if they've deemed her competent to get all that situated and then
But we still have a month and a few days before that extension is up.
yep,
So anything could be going on right now. I definitely think it's 50-50. She'll ride that train until there's no more tracks laid for her to follow. But that's just me. I just think that she will definitely milk that until they get wise to it.
see, here's the deal for me, and I heard this somebody talking on Leticia. This is, were you mentally insane when you committed the act? It's
Right.
not now.
Yep.
It's not, um, okay, I know what I've done. Now I've gone quote crazy.
Mhm.
It's when you committed the act, were you competent and were you sane?
And we have always said how far they went to cover this stuff up is
Yeah,
going to be the thing that they are not gonna be able to come back from at trial.
yeah,
And if you remember, while she's incompetent, they can't treat her for any mental illness she may or may not have. It is literally focused on the time of the murders.
yeah,
And she can say she's incompetent all she wants, but it's also competence for trial. Can she assist in her defense? That's also
yeah.
part of the competence. So,
And I mean,
you
you're
know,
sitting there watching it on TV. I
right.
find it hard to believe she doesn't understand what's going on around her, but
Right, and
with
look,
her.
Idaho doesn't have the insanity defense. Had they had it, it would be like Leticia. She would plead insanity and try to get out of it that way. So
Yeah,
she's backed in a corner. All she can do now is play dumb and
yeah,
keep saying she's incompetent or act like she doesn't know what a defense attorney does. But
exactly.
I bet she would cry when her defense attorney left, got
For real.
booted. All
He's
right,
out.
guys.
Hey, me
He's been
standing on the
quiet.
fence. What? Oh,
He's been quiet. Oh, you say he's been peeking?
yeah, he peeking on the fence. Let me in.
He got some binoculars behind the
Lori,
bushes.
where you at? Yeah.
I
No.
wonder if he does like a John Cusack say anything, gets his boom box and like
Yeah.
lifts it over his head outside the mental hospital.
I'm
Oh.
here. Yeah.
All
Yeah.
right, guys, that's all we have for today. We'll be at you tomorrow, probably with 2 episodes because we're behind today. So,
Yep.
all right. See you soon.